So what we're going to look at in this short piece are some case studies from recent English employment appeal tribunal cases, which give you the opportunity to be the judge. Dependent on which area of the world you're viewing this material, you'll need to check your own legislation, but English case law tends to be used right across the legal profession as an indicator of where decisions are going, how they're being made. So the first example we're going to use is a case called Morgan versus Buckinghamshire County Council. And a social worker gave a gift to a child in that social worker's care, which was deemed to be outside guidelines and did not have the manager's permission, and wrote up what were deemed to be inappropriate case notes and was dismissed. And in the appeal tribunal, the social worker argued that dyslexia and autism had made it difficult to be able to fully understand what the guidelines were, and was therefore in error, but not as a result of anything other than the cognitive situation that was being dealt with, in this case dyslexia and autism. However, this social worker had been offered the opportunity previously to undertake occupational health assessment to determine the nature and extent of any neurodiverse cognition issues, but declined. So when the appeal tribunal were assessing, is this a fair and reasonable thing to do, it was deemed that the council had done the right thing. They were fair in doing this, because without an assessment it was difficult for them to be able to assess future risks with vulnerable children, and so the dismissal was legal. However, after the tribunal, somebody in the council wrote to the social worker and said, you were masking your neurodiverse labelling, and as a result of that you put these vulnerable children at risk. And the social worker brought a claim that this was disability harassment under the terms of the 2010 Equalities Act, and won, because it was deemed that to write such a thing was making an implication that the social worker had behaved deceitfully. So it's an instance of the individual client, the social worker, being under an obligation to be fair and reasonable and honest with their employer, but equally the employer has to be respectful of the way they interpret the world and behave within the world. So that's an interesting, in my opinion, an interesting case of both parties having to recognise that there's give and take when working with these issues. Another interesting case study is Everett versus Regal Consultancy. In this instance, a restaurant, a fast food restaurant, had been accused and proven to have not met up to hygiene standards, and two employees were brought before the employer's own investigative panel to determine what had been going on. And one of those two people was known to be labelled with ASD, autism spectrum disorder, and requested that they have with them at that internal tribunal a family member to help them out. Now, the law does not demand that. The law said that they would be able to, or the law at that point said that they were entitled to have a trades union representative with them, but not a family member. Now, in this instance, both employees had done roughly the same thing. The non-ASD employee was given a written warning because that employee performed relatively well at the dismissal tribunal, but the other chap who'd been denied the chance to have a family member present was dismissed. And a tribunal argued that this was unfair and that under all the circumstances it would have been reasonable for that person to have been given the chance to be represented by or represented with a family member, and a substantial claim, a substantial sum of money was awarded to make it clear that this is not a trivial matter. Hopefully this will start to ripple through the world of employers and HR managers, so they understand that sums of money are involved. And in the next case, an even larger sum of money was awarded, in this case Jandu versus Marks and Spencers. So in this particular case, the Jandu had been what they call a layout specialist for Marks and Spencers, and over a period of time it had been noted that dyslexia was apparent, and that emails were sometimes reduced to bulleted or colour-coded to make allowance for and as adjustment for this particular employee to do the job competently. However, redundancies became necessary, and all employees were put through an assessment process. And at this assessment process, Jandu was told, well, your emails are sometimes appear to be rushed and not thought through. And Jandu said, well, this could be related to my dyslexia. And in the redundancy process, the comment was made, no, this has got nothing to do with your dyslexia at all. And this went to a tribunal, and Jandu won. In this case, was awarded £50,000 because it was felt that reasonable adjustments could have been made during the redundancy review process to take account of the fact that that Jandu would need adjustments made, not in the workplace per se, but during the dismissal process, as well as in the workplace, to handle both the process itself and the workload. So hopefully this gives you some idea and gives you a chance to judge yourself and determine whether, in all the circumstances, you feel that all parties were encouraged by the appeal tribunal process to behave reasonably, and that you're starting to get an impression of how this is not a one-sided approach. Each of the parties, employer and employee, need to talk to one another, be open and honest, and work towards reasonable adjustments in the workplace. And there we are again, saying it over and over again, but that's the essence of it. Hope you've got some value from these case studies.